Hello, and my name is Peter Rushmer, and I'm your host today of a Half Dozen Things podcast. A Half Dozen Things is a podcast for business owners and professionals just like you. Whether you're an underdog hungry for success or you're already smashing it but want to continue to level up, we're here each week for you to get insight and learning from the very best in the business. No fluff, no BS, and no self-proclaimed gurus talking about how easy business or life is. Just real, frank, and raw conversations. I'm buzzing to be joined today by Chris Powell from Rotheras Solicitors. He is a specialist transport lawyer who helps transport operators if they face public inquiries or supports drivers at driver conduct hearings. Today's episode is fascinating, and I'm really pleased that I've got Chris on the show for you to listen to. So I do hope you enjoy it. Take a listen, share it with your friends. Thank you. I'm really delighted to be joined today by Chris Powell from Rotheras Solicitors, transport specialist solicitor, and I've been waiting to have Chris on the podcast for a while, but he's a very busy, in-demand guy. So yeah, it's really exciting to have you and be able to hear your wisdom on today's session. So Chris, are you able to just, for the listeners, be able to introduce yourself a little bit? I know we met on LinkedIn and I dropped you a message and we've sort of toed and froed trying to get you on, but you do a lot of public inquiries. You're very busy in the transport sector. Are you able to just tell us a bit more about what you do and your background? Is that okay?
Yeah, sure. Very happy to, Peter. And yes, I know I've had to rearrange a few times, haven't I? That's the nature of the job, unfortunately. I find I've suddenly got a last-minute hearing turning up, and so things shift around. But we're here now, which is So a little bit about myself. So I started. How did I start in all of this? I actually started off in law, not doing law at all. I started off doing a history degree at university. And at the end of that, I then decided that probably it'd be sensible to get a job where you could actually do something practical. So I ended up going down the solicitor's qualification route after that. And after, I think it must have been close to 5 years or so in higher education, I ended up at a firm specialising in criminal defence originally in Nottingham. I'd always liked the idea of criminal defence. I always found it an interesting area, and so I ended up in a rather odd little job working in what was effectively a police station call centre. So that's a call centre for people arrested by the police, brought into custody, held for court the next morning, or maybe held on something, a really minor matter like a drunken disorderly, something where there's not going to be a police interview, there's not going to be a formal investigation. Sometimes it's just picking a drunk student up from the night before and holding them. I'm now entitled to legal representation, but at that time only over the telephone. So I spent a good many months, probably over a year, sitting in a call centre, speaking to people held in custody suites all around the country, usually the worse for drink or something else. And it was a bit of an odd way to get into law. And then after a little while, I ended up actually moving to another department in that firm where I was going down to the police stations in person and actually representing during interviews under caution, either by the police or CID or something like that. But it was still very much criminal defence at that point. And after a couple of years there, probably, I moved to another firm in Nottingham and started doing some other areas of law. I did a little bit of criminal still. I did a training contract, which is when you actually qualify to be a solicitor. It's like a 2-year apprenticeship. Did some private family law, so effectively rich people divorcing each other and arguing over who gets the yacht, which didn't really take my interest too much. Then
sounds interesting to me.
Well, it is interesting. I could tell you some stories. I probably shouldn't though, but
Okay.
I do remember vividly having to spend a lot of time working with another solicitor who was trying to negotiate how much a particular mooring in, I think it was Minorca or something, was worth, because that went into where this financial split happened. Anyway, it was very strange.
That's first world problems, that is, Chris.
Well, you could say that. And then the next training seat was absolutely opposite. I did a seat in court of protection. I don't know if you know court of protection. It's when somebody doesn't have mental capacity to make decisions for themselves. They are effectively held by the state in a care home or some kind of safe home where they're looked after. But then if there are arguments or discussions had about what's in their best interests, then they've got a right to a solicitor. The other family members might have a different view. So it gets very interesting. And so going from one extreme with the family law, I found myself spending probably 6 months or so, a lot of it visiting various care homes and institutions across Sheffield, North Yorkshire and South Yorkshire, and trying to, speaking to people, helping them out and that sort of thing. So complete change. And then finally, my third seat was actually in transport law. And that was the first time I actually started to experience transport law. And it was fascinating. It had elements of sort of criminal to it, in that some of the cases were being prosecuted by the Driver and Vehicle Standards Agency. There's largely a regulatory side of it, which is not quite criminal, but it's similar. It's a court hearing at which allegations are put forward and ultimately action is taken at the end of it. And so I did a training contract seat in that, and I decided I found it so interesting I wanted to qualify into it. And that's what I did. I then went and joined a specialist transport firm which just did nothing but transport law. It was a very niche practice, and for a few years I was going up and down the country representing at public inquiries, visiting operators, drivers, doing all sorts really. And then about 2 years ago now, just over 2 years ago, I moved to where I am now, which is Rotheras Solicitors. Rotheras it's a firm which does we do all sorts of areas, commercial law, private client law, all sorts. But we've got a transport department which has been doing transport law for decades now, probably one of the earliest to be operating in this field. And so there's that wealth of experience which has been really helpful to draw on. And I'm now a senior associate at Rotheras, and I'd say 90 to 95% of my practice, I imagine, is transport regulatory work, and then I do a little bit of motoring defence on the side, so drink drivers and speeding tickets and that sort of thing. But okay. That's normally when it's covering colleagues for their holiday or something like that.
That's excellent. I find it amazing that you've been through all these different areas of law, including what I would think is really interesting, like certainly family law, and then looking at certainly helping people who potentially haven't got the capacity to be able to help themselves. I imagine that's really quite interesting. But then to land on transport and go, this is really interesting, because I have that same sort of passion for the sector, and I find it really rewarding helping small to medium operators make sure that they're doing things properly and what have you. And I'm sure you get that same level of satisfaction as well when you help your clients as well. So
it's a great feeling being able to help someone turn a business around and get them from a position where they could be losing everything to having a bright future ahead of them. It's very rewarding.
Yeah, absolutely. Fantastic. Just before we move on to the next area, which is around what the role of a transport regulatory lawyer is, are you able to just clarify because I think there'll be some transport managers who listen who don't fully understand the difference between the criminal elements, the regulatory elements of what you cover and what that really means. And it actually helped me as well, I think. So are you able to just sort of cover what the key differences are there?
Absolutely. And
is that a good question, by the way? I don't know if that's
it's an excellent question. I don't mind I'm happy to admit, when I first started, first dipped into transport law, it does seem confusing. Mm-hmm. You think, well, hang on, is this there's an interview under caution happening. Is this down the prosecution route? Is this down the regulatory route? Where's the intersection between the two? It isn't immediately clear. I think probably the best way I can explain it is almost every transport-related infringement or problem is technically an offence. Not all of them, but almost everyone. Strictly speaking, every single infringement that happens on your tachograph unit is classed as an offence, and you could technically be prosecuted for it, even if it's a very minor one. But the vast majority of these are not prosecuted because otherwise there's little in the way of public interest when it's a very minor matter. 1 minute past your 44 minutes rest break rather than 45 minutes or something like that. And so the majority of them aren't dealt that way. But when things get more serious, and when you have drivers perhaps or evidence that suggests that drivers might be removing their tachograph cards to conceal the fact that they're going outside of their driver's hours rules, in other words, driving tired and trying to hide it, that's when obviously there is an interest for the Driver Vehicle Standards Agency to prosecute through the criminal courts. And so a decision gets made when something comes to the attention of either the usually Driver and Vehicle Standards Agency. A decision gets made at that point after sometimes an interview process, might be an interview under caution, what to do with that case, whether it's something that can be dealt with by the traffic commissioner within the regulatory framework, which is not guilt or innocence. It's really about, should that driver have action taken against their professional driver's license? Should that operator have action taken against their operator's license? Or should that be dealt with through the criminal arena? In other words, prosecuted at the magistrates or the Crown Court, where criminal sanctions can follow. And then after that, you can still find yourself in front of the traffic commissioner. So it's usually about seriousness. It can go either way. But to give you an indication, if you have a number of false record offences, so knowingly creating a false record, and that's usually when somebody has maybe a classic example is that somebody's getting to the end of their driving shift for the day. They've got another 45 minutes they need to take a break, but maybe they're very close to home, so it does happen. Some people will remove their tachograph card, just drive that last bit, get home, back to home before it's, without having to spend 45 minutes sitting on the side of the road. Well, what's happened there is they've knowingly removed their card.
Mm-hmm.
They've infringed their driver's hours. They've driven tired, and it's a false record on the tachograph head. Mm-hmm. And guidance suggests if you get 6 or more of those, or more than 6 of those, you can be facing ultimately Crown Court proceedings and even a term of imprisonment if the circumstances are serious enough. Mm-hmm. So it's a triage system, and it can go either way.
Yeah, absolutely. And I think sort of just to the point that you've made around drivers removing their cards, and I don't know, I assume this must be your experience as well, because when I speak to other transport managers, they say, well, drivers are idiots. They should know better, etc., etc. But actually, even despite driver CPC, I still meet drivers on a regular basis who do not realise the ramifications of their actions sometimes, or the potential ramifications, and educating them can be enlightening, I think, because they often don't realise how bad it could get when they just do, because it's a small action and it's the thin end of the wedge, and over time it can get worse. Thank you for how you've articulated that.
Yeah, I would definitely just add to that. I certainly agree. Drivers aren't idiots, but what can happen, and what I have seen happen, is particularly an inexperienced driver might join a place, learn from other drivers how practice happens, and bad habits creep in before you actually realise the implications of it. And certainly, not fully understanding what the implications from the regulator and the prosecutor's point of view. But anyway.
Yeah, no, absolutely. I think you've articulated that way better than I did, which was, and I totally agree. Drivers absolutely aren't stupid. But sometimes there's a level of misinformation or bad habit or bad practice, and sometimes you can't control the environment that someone's learnt in. For example, you could have a very good person that would never intend to break the rules, but if they've grown up in an environment which is maybe not quite what it should be, they may not know. They may not know the challenges. So, okay, brilliant. Okay, so the job of a transport regulatory lawyer, representing operators at public inquiries, representing drivers at driver conduct hearings. Are you able to just tell me a bit more about what your job looks like then now that you're in this role then?
Yeah, very happy to. So if we take public inquiries, that's probably one of the biggest things that I do, or the most frequent things that I do. As I'm sure you listeners know, public inquiry is, there are many reasons a public inquiry can be called, but it's usually when you're applying for a license or you hold a license, there is a problem somewhere. Either there's a problem with your background, your licensing background, previous criminal convictions, or there's problems with how you're running your fleet now. And it all starts usually when the operator or applicant will receive through their postbox or email account something called a calling in letter or a call up letter. And it'll be a rather scary official looking letter from the traffic commissioner saying, we've decided to convene a public inquiry, we want to talk to you, come to this location at this time. And these are the issues the traffic commissioner wants to consider. Why? And it's a list of allegations. It might be something like the findings of an unsatisfactory DVSA maintenance report, a roadside stop that happened on such and such a day where a bunch of wheel nuts were found to be loose, or whatever it is. And that's usually the first inkling that the operator has that, okay, this is a problem. Now, then normally a week or two after that, they'll receive through the post a great big pack of papers known as the Traffic Commissioner's Brief. And it's really an evidence bundle. It's all the allegations that they want to speak to you about. This is them in black and white. If a DVSA have carried out an investigation, this is their investigation report and the evidence they've found. And if they interviewed you in the process, this is the interview transcript. And it's at that point, hopefully, that the operator decides, actually, I'll get some legal advice on this one. And I frequently get a telephone call from an operator at the point they receive one of these letters, and they say, what do I need to do? And the first thing I say is, let me have a look at those papers so that I can get up to speed with what we're dealing with, what the allegations are, how serious they are. And then we will meet, we'll go through them together. I'll find out, because at the end of the day, the traffic commissioner only will have usually the DVSA officer's account and their own records, but they won't have the operator's account, and they won't often know the full background. And so it's my job to speak with the operator, find out, first of all, whether we accept these allegations. Secondly, if we do, how it happened. Are there any mitigating factors? Is there extenuating circumstances? Then discuss what have we done to fix any problems that have been found. So if, for example, we've talked a lot about tachograph offences, let's talk about maintenance perhaps instead. If a DVSA vehicle examiner's gone around, inspected your fleet, found a raft of problems, issued you with prohibition notices, gone through your maintenance records and found that they're not being signed off as roadworthy, or you've not got effective brake tests that have been happening, well, the first question I'd ask is, well, are we doing those now? Have we moved to a better garage? Have we changed our own systems or procedures so that this can't happen again? Have we got a new transport manager in? Have we spoken to our garage? Have the vehicles had brake tests now? And the answer, if the answer is no, then we'll do that. And a large part of the role is helping the operator fix those shortcomings as quickly as possible, so that when that public inquiry happens, we're able to say, or I'm able to say, if it is the case that we accept some of these allegations, we'll say, yes, those are accepted. Here are the reasons why it happened. Very unfortunate. Here's what we've done about it. And here is the evidence in black and white. The entire fleet's had, I don't know, full laden roller brake tests carried out, and they've all passed. And we've also done maybe some further training or whatever it is. And then it's that's the big picture. Then it's the actual practicalities of it, is presenting that case to the traffic commissioner, hoping as a result of that we get a satisfactory decision.
Brilliant. Okay, so that's a really interesting, because the point is essentially the first part is what really a good transport manager should be doing, which is making sure that everything is good. Clearly there's been a shortfall in the process somewhere or in the system, so it's trying to find those and carry out like a root cause analysis, so to speak, where what's gone wrong, how can we fix it and change those actions. How often and I guess the challenging question is around somebody's found something wrong in their system and corrected it, and in some cases it will be that it's an ongoing thing and people will knowingly know there's a challenge and they need to correct it and maybe haven't spotted the warning signs, and sometimes people are just genuinely just don't know that there's an issue, for example. So what's the likely different outcomes, I suppose, of that inquiry when an operator goes to meet the traffic commissioner?
Yeah, so I quite see what you're saying. I've had this discussion a number of times. If people often don't know what they don't know, it's usually when a problem's happened, when there's been a serious compliance short, it's either because it was simply not on the radar of the operator. They hadn't realised that was the level they had to meet, and therefore if they've not met it, it's because they didn't even know it was there.
Yeah, of course.
Other times, I'd say less frequently, they do know what's required, but corners are cut.
Yes.
That, in my experience, tends to be less, more infrequent, but it occasionally does happen.
Okay.
The view the traffic commissioner will take, I suppose, will depend on which class you fall into, because if the traffic commissioner forms the view that you know what's required of you, but you deliberately decide not to do that because maybe there's a cost incentive to you to not doing it, then that looks awfully lot like an unfair commercial advantage, putting commercial needs in front of the safety of the public, and that then has a bearing on whether you can be trusted or the commissioner thinks you can be trusted going forward. If, however, it is down to a lack of knowledge and the commissioner does accept and does feel that what's really happened here is somebody's not kept up to date, they've fallen behind, maybe there are other circumstances that have meant that they've not been keeping to their requirements, but they've learnt the lesson now and they can show that they've done something about that. They've maybe done further training courses and they've done what they can to turn the business around, then it's far easier for a commissioner to trust that person, because it's a sin of omission rather than a deliberate act, if you know what I mean.
Of course.
And that's it. Obviously, as a transport lawyer, it's much easier to present a case when it's founded on that.
Absolutely. Yeah, absolutely. Okay, great. So what's the difference with like a driver conduct hearing, for example, then? So what sort of things do you look at there? Are they TACO infringements, or are you more likely to see a challenge around a driver's check not being carried out properly? What sort of things are you dealing with the driver conduct hearing, for example?
There's a distinction, I suppose, between whether you're a PSV bus or commercial passenger transport driver, or whether you're HGV, because actually the requirements are slightly different. As an HGV driver, the driver conduct hearing is held to consider your conduct as a driver, and it really relates to whether you've got previous motoring offences, whether you've got tachograph offences, but it's all relating to your role as a driver. On the PSV passenger transport side, it's slightly different because you're public facing, usually you're carrying people about. The remit for the commissioner is much wider. They can look at not just your conduct as a driver, but your conduct as a whole, anything else that's relevant. And that might include other offences or negative conduct that you've done or had, totally unrelated to driving. The commissioner can consider that. So taking HGV, classic one will be tachograph infringements. It might also be driving offences generally, and they don't actually have to be driving offences in an HGV.
Okay.
I've represented drivers who have received 6 points for using their mobile phone in their private car.
Yes.
never committed a single offence or have at any points incurred through driving a HGV, but they can still be called to a driver conduct hearing.
Yes.
Because it all goes to the issue of whether they are taking the right approach to driving.
Mm-hmm.
So as a transport solicitor in that context, it's about, again, going through the scary letter they receive, finding out about the allegations, taking their side of the story, working out what's actually happened here, and working out how we're going to present the case, whether we're challenging the evidence, whether we're accepting it. If we are accepting it, what are the extenuating circumstances surrounding that? How are we best to present that? If further training courses are required, we can look into that. The way driver conduct hearings work tend to be quite different to that of a public inquiry. They tend to be far shorter, and the commissioners, I've turned up and represented at a driver conduct hearing where there have been maybe 15 drivers in a room, and they each get 5 minutes each to go through.
Right. Okay.
Others have lasted half a day, particularly if it's connected to a full public inquiry hearing.
Okay.
So it's quite a mix.
Okay, fine. And from a driver conduct hearing point of view, that's interesting to hear how quick sometimes they can be. I suppose there's much less complexity to potentially that there's a situation and something wrong has occurred, and it's a bit more of a straightforward thing. But yeah, one of the misconceptions I think I find when we do driver CPC training, for example, is that drivers think that their vocational license and their car driving license are there's an element of separation, and sometimes they don't realize that if they get caught in their car doing things that they shouldn't be, that can have an impact on their vocational license and potentially end up in a driver conduct hearing. So yeah, really, really good. Okay, so DVSA interview under caution, what does that look like, for example? So I've never experienced an interview under caution. I have sat in on DVSA coming in and doing audits of an operator on several occasions, and usually we get a traffic examiner come in or a vehicle examiner come in, and they come and look around the vehicles, look through our paperwork. What's the key difference between that and an interview under caution, for example?
So what you just described sounds like a visit report or
yes,
something like that, and as you say, they're very, very common. They're not an interview under caution, they're more an audit, really. That's what they are, a checkup.
Yeah. It's often, in all honesty, I've come across it. There may be a previously disgruntled former transport manager or driver, for example, that may have reported something, and the DVSA are then following up based on intelligence that they've received. And yeah, oftentimes the allegation may have been unfounded and the audit proves such, for example, but nonetheless they have to follow up on these things, don't they? So yeah, and sort of what does an interview under caution look like in comparison then?
So if, for example, that audit, they go through your raw tachograph data, or they go through usually it's the tachograph data or something similar, and they find actually we've got all of these instances of drivers of this company have been maybe driving without a card in, or we've got vehicles being used without a card in, or perhaps we've got a bunch of the drivers have CPCs which have expired, or maybe the company itself has had MOTs missed and been using a vehicle without MOT. That's when, as I said earlier, these matters are all technically criminal offences. And so the DVSA have to make a decision as to whether these are things that they need to prosecute, or things they need to deal with through the regulatory arena, or things they need to take no action on. So they've got to give the operator or the driver or whomever they want to speak to an opportunity to respond, and that's why an interview takes place, but it's under caution. And under caution is the standard wording: you do not have to say anything, it may harm your defence if you fail to mention when questioned, etc., etc. And the reason you're given that caution is because at that point DVSA don't know what you're going to say and what your response is, and they don't know whether or not you're going to end up being prosecuted or no action at all. So they give you the formal caution, and then they interview you using the standard procedure under the Police and Criminal Evidence Act. So they'll write down, ask you a set of questions, they'll show you the evidence, they'll ask you to respond, they'll write down the responses, and then they'll ask if you've got anything else to add. They may challenge your evidence, and at the end, that will be a formal interview that's taken place under caution, and that in the worst cases, will end up as Exhibit A in a Crown Court prosecution, or it might just end up before the Traffic Commissioner in a conduct hearing or a public inquiry. And so the role of a transport lawyer in that scenario is to get in touch with the DVSA beforehand, ask to see copies of the evidence, whatever they want to put to my client, so that I know what the questions are going to be. I have a chance to speak to my client about those and find out what our response is. And very often they might say, we want to ask about these 5 things. And when you actually find out in advance what those things are and you have the chance to have that conversation, the operator might say, oh yes, don't worry about that, because here is the explanation for that, and here is the evidence on file to show that that was not an issue at all. In which case we go to the interview under caution, we present the evidence, and we would on that issue, and we would hope to have that discontinued. And whilst a lawyer is not allowed to actually give answers on behalf of their client, they are allowed and indeed expected to help their client give their best evidence, make sure the interview is conducted fairly and that there's no abuse, which is quite rare, but occasionally it does happen. And also, to a certain extent, although this is outside the interview process, have a bit of a discussion or negotiation with the DVSA officer to get a bit of flavour as to which direction this is travelling, whether there's any alternative routes that this could go. And that would be the role in that situation.
Fantastic. That's actually really interesting. I suppose that the stress that your clients are under when that happens, when that interview is going to happen, and I suppose that there's people who decide that they're not going to invest in a solicitor to help them, or a lawyer to help them, and actually there's quite a lot that you can do to support and help someone in that situation to make sure that it goes in a much more favourable scenario, because you've got the understanding, you've got the experience, you're able to help with those things and help to negotiate and guide and have the understanding to be able to help people not to dig themselves a big massive hole, which they don't necessarily need to dig.
Well, it's very frustrating when I get contacted at the public inquiry stage, or maybe at the court prosecution stage, and I go through the papers and I see the interview transcript of maybe a person who decided not to get represented. And then you speak to the client about it, and it turns out that they had an explanation all along, but they just didn't know what they were going to be asked about in advance. They didn't really know what was expected and what evidence they needed to provide. And at that point, you can say, well, actually, this isn't anywhere near as bad as it appears. We might not even have had to be here had we dealt with it properly at that early stage. But it's much harder to deal with it much later, because absolutely. Part of the wording of the caution is, if you fail to mention when questioned something you may later rely on in court, if you fail to mention it back then, or fail to give your best evidence at that crucial interview under caution, and you later try to rely on it at court, then you get what's known as adverse inferences, and it can be very much more difficult. So I would say this as a lawyer, but I would also say this as somebody with a lot of experience in transport. It's the most crucial opportunity you have. If you're being interviewed under caution, that's the opportunity to do everything you can to stop it escalating down a criminal route, to get some help.
Yeah, early intervention. Like with anything, early intervention is always the best way. Absolutely. And usually the most cost effective anyway. So, yeah, absolutely. Okay, fantastic. So one of the other points that we were going to look at was around illegal migrant stowaways. So that's something that's coming on the radar a little bit more. Particularly yesterday was in the news, because we had a record number coming across in their dinghies across the channel. So yeah, talk to me a bit more about that sort of situation, because operators can find themselves inadvertently in quite a lot of hot water.
Oh yes. I mean, there's a distinction to be drawn here between the fairly small, more rare occurrences of some organised groups or operators who may be part of a deliberate attempt to smuggle illegal migrants into the country. So, for example, that absolutely tragic incident with a couple of years ago, with a large number of dead illegal immigrants in the back of a container. So those are quite few and far between, those situations, but they do happen. The far more common scenario is operators who are bringing goods into the UK, bringing trailers, tractor units and trailers into the UK, and are the victim of stowaways. There's a very, it's commonly in the news, the Road Haulage Association, Freight Transport Association, or Logistics UK as it is now,
Yes.
have talked at length about this. In northern France, there is a migrant crisis. There are organised gangs, which both the French and the British police are doing their utmost to counter. And they are trying to assist illegal immigrants to break into the back of trucks bound for the UK, hide them in there, and then they've gained unlawful entry into the UK. And the sophistication of these has been increasing over the years. And it's quite common that now you'll see examples of padlocks being cut and then super glued back together once they're back in. Some quite sophisticated entries, particularly from the roofs of some of these vehicles, which a driver couldn't possibly spot on a walk-around check, and all sorts of other methods. And unfortunately, if you're an operator or driver and you get stopped at the UK immigration zone in Calais or in Dover, if you've got to the other side, and you get inspected and it's found that you've got illegal immigrants inside your tractor unit, even if you've got no idea about it, you can face a fine of up to £2,000 per migrant. So if you've got 10 migrants in the back of your truck, you could be looking at £20,000.
Wow.
And sometimes you can get a lot more than 10 migrants in the back. And that only has to happen once for a fairly small operator for there to be a real risk to the business as a whole.
Absolutely.
So what I do, part of my role is helping those operators present a case to the border force as to why these fines are excessive or shouldn't be levied. In other words, you will receive the fine unless you can show that you have effective systems and procedures in place to stop migrants getting in. So they expect things like a walk-around checklist, looking specifically catered, not a defect check, but an actual checklist to make sure you don't have any signs of forced entry or anything like that.
Yeah.
They expect written instructions and a company policy on these matters. They expect your vehicle to be secure. They expect you to have trained the driver on what's expected. They expect there to be a monitoring procedure. So it's quite a lot. And very often, an operator will have all of these things or a number of these things, but just be unfamiliar with the process and not really know how to respond to it.
Yes.
And a part of my role is to help put together a case for why these penalties might be excessive. Sometimes you can make a case on financial hardship grounds, and had quite a lot of success in getting some very sizable penalties down, sometimes cancelled altogether and sometimes down to just a few hundred.
Amazing.
So it's an interesting area of law. It's only going to be increasing at the moment.
Yeah, absolutely, and I think I totally agree. So it's a growing challenge, isn't it, at the moment, that I think operators are facing. And yeah, fascinating that you're able to really help by understanding the system, by understanding the process, help to support operators with making sure that we can reduce those fines. Absolutely fantastic. Talk to me a bit more then about moving on to whilst we're talking about sort of borders and what have you, border force and truck seizures. Then what does that entail then, Chris?
Well, this is typically something that is less common in my experience than the others, but a lot of it relates to excise goods, so tobacco, alcohol, or some problem with the paperwork of a load, or maybe in some cases a groupage load that's come into the UK might have, and I've come across it, a pallet which when you actually inspect it has got a bunch of cigarettes rather than the car parts, which it says on the manifest. And so, unsurprisingly, if that happens, the border force will seize the tractor unit and the trailer and just all the goods, and it'll all be held up. And you can often find that there's maybe loads belonging to 3 or 4 different customers in the back of that truck, and they've got no involvement in this. All they know is that their truck's been held, their load's been held. So if I can be contacted sometimes by a customer, I've had one a few years ago from Austria with a very crucial part of a manufacturing plant that needed to be delivered. on time to a location in the UK. And they were at the stage where that part had been held up for 3 weeks because I think it was something like it was either cigarettes or drugs had been found in one of the loads in the trailer unit or something, not connected to this customer. And they were at the point where they were almost going to have to manufacture a whole new part of this huge machine to get it shipped to the UK, just because this thing wasn't moving and it was holding up a production line. And so a lot of it is trying to negotiate the release of that sort of thing as quickly as possible. Sometimes if I'm approached by the haulier, it might be that the haulier has, at the end of the day, a haulier, particularly if they're picking up a preloaded trailer, or if they're picking up goods that have been loaded by somebody else, they've got responsibility over what they're transporting. But in reality, it's impossible, really. It was very difficult for a driver to inspect each and every load, particularly if they're wrapped or whatever. And so often it's making representations to the Border Force for the release of that tractor unit and trailer by providing evidence that they'd done all they can to assess the load to make sure there wasn't anything untoward being carried. So it's a bit of a minefield. It's quite complicated when you've got these long supply chains with lots of different parties involved. And I suppose my job is to help tease that all out and try and get the goods back, get the vehicle back, whatever it is.
Yeah, absolutely. And I think the key thing there is you've got this complex supply chain, but at the end of it, there's an operator who's really, really suffering because the vehicle's tied up and their trailer's tied up, the rest of the goods are tied up, and they're going to have penalties for the other goods and all of those challenges. So yeah, no, that's fantastic, fantastic service that is offered there. Amazing. Okay, so next up, I wanted to ask you a bit more about public inquiries, if that's okay, because I think that's going to, a lot of the listeners will get some real value from understanding that many may never have been in an inquiry, and it's something that's quite scary and what have you. Rightly so, obviously, but it's just sort of daily stuff for you, Chris, right? So do you represent operators across all the different traffic areas? So you deal with all of the different traffic commissioners on a regular basis?
Yeah, so Edinburgh to Eastbourne is what I tend to say. Every traffic area. The only place I don't typically go is Northern Ireland, and it has actually been a few months now. In fact, a little while since I was last up in Scotland. So, but typically I will cover every traffic area. It's such a niche area of law that you really you have to do that.
Excellent.
So what is a public inquiry like? That's a very open-ended question, but I'm going to...
Of course, yeah, sorry.
No, it's absolutely fine. I'm going to try and answer it as best I can. I suppose listeners are going to be most interested in what it is practically like for them. What's the experience like? So we've talked about, it starts off with the scary letter and the list of things they're not very happy about. Then it will include in that letter a list of your document that you need to send to the traffic commissioner before the hearing. And that can be a little bit unnerving itself, having to collect your last 12 months of maintenance records and tachographs and send them all into the regulator. It's always a bit of a stressful experience. And then at the inquiry itself, the best, it is a court hearing ultimately. The traffic commissioner will sit up on a bench with a big crest behind him. There'll be a clerk in the room usually, and then there'll be the operator, any transport manager, any DVSA examiner who's present as a witness, any other witnesses in the room. Obviously, if you're legally represented, lawyer in the room, there might be members of the public at the back. It's a public inquiry, so you could have anybody walking in. Typically, members of the public find better things to do at their time than to turn up at a public inquiry, but it does happen. You also might get journalists there occasionally if it's an important enough case.
Yeah.
Particularly with passenger transport, you might get members of the local authority there because if they've got contracts with that operator to carry their school kids, they're going to want to know what's happening.
Of course.
And you might also have a driver present if there's a driver conduct element to it. So it can be a pretty big experience.
Of course, yeah.
And it's a formal setting. So the traffic commissioner comes in, the courts, everybody stands, wait to be seated, and then remain seated throughout, typically. And it's the key point, I suppose I would say, is it is an inquiry. The clue's in the name. It's not a criminal hearing, it's an inquiry. So the traffic commissioner is entitled and will inquire into any area they want to speak to, and they've got control over the format of that hearing. So some traffic commissioners will take a very formal approach to it. They will say, here are the issues I'm unhappy about. I'll listen to some opening submissions from your lawyer, perhaps. I then want to hear from the DVSA officer. You then have the opportunity to cross-examine that officer if you disagree with their evidence. They then want to hear from any other witness. They then want to hear from the operator or whomever. And if they're legally represented, the lawyer will take them through their evidence in chief, not being allowed to ask any leading questions. And it's a very formal setting in some cases, and the commissioner will ask questions directly of the operator. They will take an active role in questioning anybody they want to in the room. It's not like a judge in a trial who will typically sit back, let the advocates go through the evidence, the jury present listening, and then the judge being largely impartial. The traffic commissioner will get involved, and it can be quite challenging at times. Other traffic commissioners take a slightly different approach, and the hearing is more flexible. They will be happy for the lawyer to take more of an active role in presenting their client's case. They might be happy to hear from witnesses at different times as required, as the evidence goes on. And sometimes the hearing can be quite challenging. Different commissioners take a different approach, and some can be quite robust and can robustly challenge an operator, and sometimes the lawyer if they don't agree with the submissions, and it can be a very stressful experience. Other times it's a little bit less so. And then at the end, closing submissions will be made. There's the opportunity to address the traffic commissioner on things like what effect any decision might have on the business, any reference to statutory guidance documents. In other words, in the criminal arena you would call it sentencing guidelines, but statutory guidance on what sort of action the traffic commissioner could take. You could refer to various bits of upper tribunal case law. And then at the end, the traffic commissioner will either make a decision there and then, or will release a written decision in due course. So that's a big picture overview of how a public inquiry actually functions.
Excellent. I think obviously it's very broad depending on what the subject is and that kind of thing. I think one of the questions I've got for you is, with the experience with the different traffic commissioners, there's different styles by the sounds of it of how relaxed they are about how that process is carried out. I suppose that will also depend on the severity of the inquiry. For example, whether it is, we need more information about this license application, where potentially there's no allegation of any wrongdoing. It may just be that it needs more information. They're not quite happy to sign off on an O license, for example. I suppose that's a bit more of a question and answer, a more relaxed situation, for example, is that?
Absolutely. Some inquiries can be all over in 15 minutes. It's very rare, but I've had some cases where actually the confusions that arose during the application process, there's a perfectly innocent explanation if you put in some written submissions in advance and you can explain it all. And a public inquiry in those cases can be little more than turning up and the commissioner saying, well, I've looked through this, I'm largely happy with how things go. Is there anything else you want to add? I've gone through your records and perhaps I don't have any concerns. And that's it. And it's much more flexible and more informal. Other times, if the wheels come off on the M6, and if thousands of missing mileage have been found on your tachograph unit or whatever, then it's going to be a much more like a formal court setting. It can almost feel like a Crown Court trial at times. So it's the whole spectrum.
Yeah, excellent. Which I suppose makes it so interesting for you as a as a person who gets to go and represent operators in these public inquiries. It's quite an interesting place to be, I suppose, and it's very varied in the role and the way in which you get to carry out your work, which I think is amazing. Okay, so just sort of I guess sort of closing questions from me. Could you just let me know a bit more about maybe what most rewarding or most challenging case has been previously? I suppose records are publicly available, but at the same time, I don't know if you need to client confidentiality or what have you, but share as much as you're able to, I suppose.
I think as long as I don't name names, I should be okay.
Good.
But let's start with a challenging one, only because they tend to be the ones people are interested in. I did have a case, I think it was a scaffolding company a couple of years, no, only about a year ago, a bit longer than that, whatever it was. And it was a challenging case from the get-go. I remember those driver's hours issues, maintenance problems. There'd been a history of operating without a license. There'd been a history of a bunch of different companies. From the outset, it was a real challenge. But we'd managed to do quite a bit to turn things around, and we were had the odds stacked against us, but we were hopeful we would be able to scrape through. And then about a day before the public inquiry was due, I received an email from the Commissioner's office to let me know that was I aware that my client a few years previously had been convicted of quite a serious criminal offence which hadn't been declared. That I was entirely unaware of. And it was quite a serious offence. And at that point, I think I was sitting in my hotel room prior to the hearing, because I'd stayed the night for some reason, and I thought, well, that's going to make a very, very difficult case, possibly insurmountable, and certainly it didn't go too well in the end. But you often find that kind of development at the last minute. Things will suddenly pop up, and so it always helps if that is something. It's more helpful for your own lawyer to be aware of these things. I say,
of course,
if I don't know about them, there's the opportunity for us to be blindsided. Whereas if we knew about it at an earlier stage, we can sometimes do things about that. So that's a challenging one. The more rewarding ones, rather than any particular one, to be honest, it's just a good feeling where, and this goes back to what we discussed earlier, it's a good feeling when you've got an operator who is fundamentally trying to run a decent business, but something has gone wrong. Maybe the person who used to manage their transport has retired, or maybe there's been a personnel problem, or maybe the company's grown too fast and has failed to keep up with compliance, or whatever it is. Sometimes things just go wrong through no intention. And you reach a stage where an operator gets that horrible moment of realization when the DVSA come knocking on the door that things have gone wrong. And if at that point I get a call, I'm able to go in, I'm able to help them out, talk through what's gone wrong, come up with a plan about what we're going to do to fix it, and be in a position by the time of the public inquiry to say to the Traffic Commissioner that, yes, if we might accept that what happened, and it was entirely inadvertent. It was a wake-up call at the point this came to our attention, and we've acted quickly, effectively, and meaningfully to turn this business around and to make sure that all the compliance issues are dealt with. The Traffic Commission is usually very amenable to that, and they're not a criminal court. They're not about guilt or innocence and punishment. They're about, can I trust this operator going forward to operate compliantly? And if, as an advocate, if you've advised early and you've got the evidence to support the case that you're making, and you can show that this person can be trusted, and the Traffic Commissioner agrees with you and lets the business to continue, maybe with minor action taken, that is a very rewarding feeling, and it's obviously great for the client. But it's great for the advocate, because it means you've maybe been part of saving a business that might employ lots of people, might have a long history, might be a family business. Keeping them on the road is a great feeling, and so that's what makes the job worthwhile.
Oh, amazing! I think that's It's definitely must be such a rewarding thing to be able to support with. I think I've thought of one final closing question, which I think is a bit more fun question. So, well, if I was in your position, this is probably more a reflection on me than it is on you. I would definitely get the reward out of supporting operators in the way you do, and I know I sort of have a relatively similar role in sort of managing clients on a day-to-day basis with their compliance. But I think if I was in your position with the information, I would have a bit of a game with myself as to guess what the outcome's going to be, or what I expect the outcome's going to be. And I bet you've got pretty good at it, depending on who the traffic commissioner is and what the offence is. Is that something you do?
I think every lawyer has a feeling as to where something might be going, but I have to heavily caveat with that you can really be surprised at times. I've had cases where I've thought I really think we've got one hell of a fight on our hands, and I've been surprised at actually it's not been anywhere near as bad as I had anticipated. I've also had cases where I felt quietly confident and unfortunately been rudely surprised. So yes, certainly over time you learn, you practice, you learn what likely outcomes are going to be. But at the back of my mind, I'm always wary that you never stop learning in this job, and Absolutely. You can always be surprised.
Absolutely. Fantastic. It's been great to meet you, Chris, properly, and to have you on the podcast as well. And it's great to see that the things that you're passionate about are shared, particularly amongst people who listen to the podcast, and certainly myself as well, about helping family run operators and transport operators to stay in business, keep people employed, and to keep the roads safe, which is ultimately our goal, right? So thank you very much for joining me, Chris.
It's been an absolute pleasure.
If people want to sort of get in touch with you or get in touch with Rotheras, how do they do so? How can you help them? Where do they find you? Is it LinkedIn the best place to come and find you? And how do they get in touch?
So anyway, really, I am on LinkedIn, but also the Rotheras website. You'll find me if you type my name I tend to find if you type Chris Powell, transport lawyer or solicitor into Google, I'll usually pop up somewhere. Or likewise, it might be my contact details can be attached to this podcast or this or the visual version of it. I'm sure there must be a way of that happening.
Yeah, absolutely. So I will share your contact details on the podcast too, Chris. So yeah, finally, thank you very much for giving up your time to join me. It's been absolutely fascinating. I really do appreciate it. Thank you.
My pleasure.
And thank you to everyone listening. We'll catch you again soon.
I really hope you loved today's episode, and if you did, please make sure you subscribe and listen out for future episodes too. Please do share it across your social media channels. We hope to reach more and help more people. If you want to find out more about me, my name's Pete Rushmer. You'll find me across any social media channel and my business Flagship Partners, and we're your partners in success across your business. Thank you. See you again soon.